This is the Norwegian Supreme Court. So we're going to go in there for a visit. Come on, let's go.
Welcome. This is the intensive course on human rights at the Norwegian Center for Human Rights. And we have the pleasure of welcoming Erik Møse, Høyesterettsdommer, Supreme Court Justice in Norway. And I understand that you have a quite interesting background in human rights, that you've been a judge at the European Court of Human Rights, and you've also been a judge at the International Tribunal for Rwanda.
Yes, that's true. I spent 10 years in Africa, and I was president of the NCHR, the Rwanda Tribunal, for 4 of those years, and it was a fascinating experience. And it's true that I have also been in Strasbourg for about 7 years as a judge there, yes. And I've enjoyed working with human rights my entire professional life.
And so now you are a justice here at the Supreme Court in Norway. And if you could just tell us a little bit of the background of the Supreme Court here, this gorgeous building here. Do you know how long the court has been here? Has the court been in existence since the beginning of Norway? A little bit of background.
Yes. As you may know, the Norwegian Constitution dates back to 1814. And the court is mentioned explicitly in the Constitution. So that's when it was established, and it was factually established. It entered into function the next year in 1815. So it has a tradition of about 200 years. In the beginning, it was moving around in Oslo, the capital of Norway. It did not have its own house. And that happened. That took place for decades, but in 1909 approximately, this rather old-fashioned building was erected for all 3 instances at the judicial level: the Supreme Court, the Court of Appeals, and the City Court. And the Supreme Court was then on the top, on the 3rd floor, whereas the first instance was, of course, on the 1st floor. And this went on until the end of the 1990s, and then the Supreme Court took over the entire house, the whole building, and we've been in that building since then. And we are now we are 20 justices, 1 Chief Justice and 19 other justices, and we have also some law clerks and administration. In total we are about 50-60 persons.
There's a lot of people in the course who are interested in the rule of law and how that works. And in the Supreme Court here, how many justices does it take when you decide a case? Is it just a simple majority? And do all justices sit and listen to every case?
There is a composition, there is a possibility that a court may sit in plenary, all 20, but that is rather seldom. So generally we sit in composition of 5 judges in each case: civil cases, criminal cases, administrative cases, constitutional cases, because what is special to this court is that it has general competence. Norway does not have different branches of judiciary. It has only one branch, and that's why this court has a very wide competence, unlike most other courts in Europe. And so we sit 5 in each case, but when it comes to deciding whether a case should be admitted to the Supreme Court, that takes place in writing. It's a written procedure, and there are only 3 justices in making that decision. In addition to these 5 judges sitting in the composition and the plenary. There is something in between, because plenary is a very cumbersome organization, of course. So we have also this grand chamber composition of 11 judges. And that is used when there are questions relating to important human rights issues and some constitutional issues.
If someone's going to bring a case to the court, how do they appeal? You don't have to go through the whole procedure of appealing, but how do they get to the court? And is there a fee for them to get to the court?
Also, the main rule is that there is a fee, not in criminal cases and not in some other cases where there is an element of vulnerability, to put it broadly. But and there is no right to get into the Supreme Court. It will be for the appeal selection committee with the 3 justices I just mentioned to decide whether it should be admitted or not. What is essential in deciding whether a case will be allowed in is, of course, whether it's a matter of principle, whether it raises interesting questions which can clarify the legal position for the future. But of course also we do take into account whether it's very important for the persons concerned.
You mentioned that there's 20 justices of the court. How are they selected?
They are, in principle, there is a decision by the King in Council, but that is the procedure mentioned in the Constitution from 1814, which has of course been amended subsequently. But the reality is that there is a huge degree of participation in the process. It's very transparent, it's opened, people apply for the post, the list is public, people are interviewed, the short list is public, and this in a way opens the procedure. And then the justices and the court is taken is involved in the decision-making process. So it's not the kind of state where there is the administration deciding who should be the justices. It could look like that on paper, but in fact it's a rather open system. But it may be argued that it should be stated more clearly, of course, that this is the procedure.
Are all the justices lawyers or legal background?
Oh yes, of course, all. But they have a very different background. Some will be judges from the Court of Appeals or the first instance. Others may be practicing lawyers, barristers. We have had some professors. And some come from the ministries. But generally, I think that the best chances to succeed in order to get here is if you have practical experience, either as a barrister or as a previous judge. I think that is the experience generally.
What's the diversity of the makeup of the 20 justices?
We have a large percentage of women. It's not 50%, but close to, a little bit less. And we take into account the need to have a balanced composition, not only gender-wise, but also geographically. Of course, that depends on the situation. If only people from certain regions apply for the court, you cannot get those who are not applying. But provided that the individual qualifications of the persons applying to the court, and they have to be of a certain standard, of course, that is for sure, then one element would be to have a mixed composition to the extent possible. We don't have any immigrants for the time being. Maybe that will come in future. It depends on the development. You need to have the high legal level, and only then can you select between them.
How long do the justices serve?
Well, we retire at 70. And there is no exception. This is not like the US Supreme Court when you sit almost eternally. At 70 it's over. The question about when you are appointed differ. Some get in perhaps in the 40s or early 50s, others enter the court around the end of the 50s. But it's very unusual that anyone would be appointed to the court after 60. And I think it's fair to say that it is also important to have some kind of diversity age-wise, in the sense that there is always a continuity in the composition. It would be unfortunate if suddenly, say, 12 justices were retiring within a couple of years. So that doesn't happen.
So it's a life appointment, but you end at 70?
Yes.
Yeah. So the justices, of course, they decide cases and follow cases, but do they have any other duties, like oversight of the judiciary branch? Or?
No, we don't have that system which occurs in some other countries. We focus on judging, on the individual cases. There is a particular organization or bureaucracy in one of the cities in Norway which has that as its main task, to some kind of oversight, but not for the substance of the cases, of course, just for the functioning. But oversight is not one of the functions of the Supreme Court.
If someone brings a case to the Supreme Court and they are representing themselves, well, first of all, do you have many cases where someone represents themselves, or is it even possible to represent yourself at the Supreme Court?
It almost never happens. All the cases coming in here are complex cases. And we also know of experience, all of us in all countries, that to be one's own lawyer is not always the best idea. So I can say that in practice, at least I have never experienced it. There will always be a lawyer representing the person concerned.
When someone brings a case and they have a lawyer with them, they have a case that's so important it comes to the Supreme Court, are they entitled to public assistance to get an attorney or to pay for an attorney?
Yes, and again, that depends on the cases. For instance, criminal cases, as I mentioned, is one example. And there is a set of rules governing the right to free legal aid, which is frequently, or at least to some extent, used in some civil cases, if you qualify according to the regulations. And that's partly economical and partly the character of the case, including the person's vulnerability.
From the time a case comes to the court, how long does it take before a final judgment is reached? Of course, they vary greatly, but is there a general length of time?
The Supreme Court is keen on delivering justice within reasonable time. So we try to, of course, quality is of the essence all the time, but I would say that it will usually not take more than 3 weeks until judgment is rendered. And that also goes for the complex civil cases. If there is a grand chamber case or a plenary case, then you could well imagine that it takes more than a month, maybe 6 weeks. But that is more an exception. So we are actually a bit proud of our efficiency here in this building.
Yeah, that is quite efficient. That's quite fast. When the court decides cases, and I guess this goes for Norwegian law as a whole, what are the sources of law? And in particular, does the Supreme Court here often use international law or regional European human rights law?
It has been a fantastic development with the court opening towards international sources the last 20, 30 years. It began very modestly in the 1960s. In the 1960s, I think there were 2 cases where the European Convention was invoked and it didn't succeed. And in the 1970s, I think there were 4. But gradually in the 80s and 90s, it more or less exploded in the 1990s, partly because a new constitutional provision and partly because of a specific incorporation act which assisted a development which was already in progress. So I would say that human rights conventions are, first of all, they take precedence, in particular, some of them, namely the European Convention on Human Rights and the 2 covenants, just to mention them, plus the UN Child Convention. They take precedence if there is a conflict between the convention and national law. And it almost, I think you could say that applying human rights law is everyday life in this court, in a way. There are so many cases every year. I just made in connection with an article I wrote a few years ago, I noted that maybe 30, 40 cases per year at least. And that is a large number if you look at the total number of those cases admitted to the court.
Is that a reflection of the most important cases that reach the Supreme Court are cases that involve important issues of human rights?
I would say that the fact that a case raises an important human rights issue is clearly a factor of great importance, whether it should be admitted or not. And that has partly something to do with the rights of the individual, of course, but it also has something to do to get the decision right, because it's also a matter of making sure that there is sufficient quality and consideration of an important question of principle before it goes on to an international body, say the Strasbourg Court or a UN committee.
Does the court ever look to general principles of law from other countries?
Yes, comparative law is a source, but here it depends very much on the kind of case, of course. But if you look at the Nordic countries, you will note that in some areas of law, the situation, they are very closely connected, so there are not much difference. But and then, of course, it will be of great importance if, say, a Swedish Supreme Court has made a ruling on more or less an identical provision which was enacted in common between the Nordic countries. But we take also into account judicial decisions from other countries, and of course EU and the economic community. In general, I would say that the Norwegian Supreme Court has a rather open attitude to external sources, maybe traditionally more than some other Nordic Supreme Courts.
In your experience, is the court affected in any way by moral or social norms as well as sort of an informal source of law?
Yeah, how would you specify that question?
When perhaps society is changing and there are new norms are developing, does the court feel some sort of pressure to adjust to those new norms?
Not pressure, but I do think the court considers it important to be in tune with societal developments. Otherwise it would become irrelevant. And it's, as I said, one of the court's tasks is to clarify the law, and but another important is to develop the law. Another important role is to develop the law according to the circumstances. And there is, of course, a balance to be achieved, but we do.
When cases are decided at the European Court of Human Rights or at the United Nations treaty bodies like the Human Rights Committee, is the Norwegian court, does the Norwegian Supreme Court feel bound? Are they bound by these decisions that are made?
Well, as you know, it follows from the convention that the judgments are binding for the state. And needless to say, the court will certainly follow case law from Strasbourg and also place great emphasis on jurisprudence from the UN committees. So it's being taken very seriously, and a very good example recently has been the child welfare cases, which have been subject to some debate in this country, and following a Grand Chamber case recently against Norway. We adjusted to clarify and make sure that the child welfare authorities will, in a way, take a slightly different course to make sure that they apply the criteria developed by the Strasbourg court. So the answer to your question is clearly yes.
I'm curious, it seems that the court is very open to the international developments at the European Court and the UN treaty bodies. But is it also, is there any cooperation with other judges or other judiciary branches in other countries?
Well, in particular, we are of course part of what you could call the Supreme Court networks which exists. And we also have an even closer cooperation with the Nordic Supreme Courts, which are very similar to this court by tradition in a way, even if there are differences between them. How does that cooperation manifest itself? I would say that it's normal that the Chief Justices meet, say, once a year, and there is also usually an annual meeting between a delegation from all 5 Supreme Courts to discuss matters of common interest.
When there on occasions can be what's been called conflicts between human rights, how does the Supreme Court deal with those? For example, conflicts between freedom of expression and freedom of religion.
Now that's the eternal question. It's a problem for the Strasbourg Court. It's a problem for the national. How do you balance human rights against each other? And I think it's almost impossible to answer that question in a general way. But it has simply to be done by a careful balancing of the two norms. Very often you will note that there is not so much a matter of conflict, but rather a matter of adapting and applying the two norms in light of one another. That's what you see often in Strasbourg. You don't often see, or it's usually being formulated by the European Convention being interpreted in light, say, of the Child Convention or the Racial Discrimination Convention. And I think we use, in a way, the same technique, taking all norms into consideration. After all, there is this new word, fragmentation, and I think it would be unfortunate if there were to be a situation where the human rights norms develop into a fragmented way. It's much better to interpret the norms in a way which shows that they are, in a way, reconcilable, and that they are universal norms and not with different weight on different rights depending on the body in which you are sitting.
That's a very interesting conceptualization of that, to put it in perspective of the human rights are universal and trying to find. Yeah.
Yes, I think so. But my experience is really that the more you go into detail, and this, the more you are able to find solutions which are fair, using legal methodology and striving to find the right conclusion in a way. But of course, sometimes there is tension, and then you simply have to decide. And that is clarity in itself.
Norway is a very wealthy country. In Norway, is there a human right to be free from poverty?
Not in the constitution, I think, but it isn't. But of course, we are all aware, those of us who are interested in human rights, that there is at least there have been a debate about the protection against poverty for a long time. I don't think you will find, there is no explicit provision in the Constitution or in any particular legislative regulation formulated the way you put it. But of course that's underlying the whole social system. So the whole social security system and the means available to persons in acute need, which are available partly through legislation and partly through budgetary appropriations, is all directed to achieving that aim. But of course, it's not an easy way to formulate such a norm in a justiciable way. But I think we could say that the system is based on the aim to avoid it. Whether there is a norm of, whether there is a gap between norm and reality from time to time with respect to some persons, it may happen, but of course that's again the eternal question.
That's been the eternal question with socioeconomic rights as a whole, is how to find ways for courts to be relevant in enforcing them or making them reality.
Yes, we are this is a logical follow-up of the next question and of the last question you posed, and we have had quite a few cases, but not that many as with respect to the Covenant on Civil and Political Rights, and in particular the European Convention, which is really dominating our international jurisprudence which we apply here. But we've had a few cases involving the Covenant on Economic, Social and Cultural Rights, or say the European Social Charter in Strasbourg, but they are also norms that are incorporated and are weighty arguments in our judicial process.
Well, we have a question about cultural rights. Has the court had cases that have involved cultural rights and upholding cultural rights, and in particular toward the Sami cultural rights?
Yes, we have. And the most famous one was perhaps the so-called Alta judgment back in the 1980s, which involved, this was about the exploitation of a waterfall, and the question was whether it was allowed to exploit it, which could potentially affect the Sami culture by having implications for their reindeering, so to speak. In that case, the resolution of the King in Council, also of the government, to exploit the waterfall was not considered invalid, but in that process the court had to take into account whether that would breach cultural rights, and there have been some other cases as well.
So does the court then have the authority to overrule an indigenous group who have not given their consent to a project such as the waterfall project?
So the court will have to find out what is the requirement of international law, and will a particular decision or a general act being applied in a concrete situation violate human rights. And if it does, the court has the power to overrule, yes. But I'm not really aware that it has happened with respect to a cultural right, which you are asking me about now. But we have very many examples, of course, with respect to other rights. Criminal procedure, freedom of expression, racial discrimination, where the court has given precedence to the human rights case law and turned down the domestic solution.
You mentioned cases about racial discrimination. We have a question about whether or not the court has examined many cases of police activity toward ethnic minority groups. And has the court dealt with many of these cases, and how has it dealt with those cases?
At least, I think this is part of society as it stands now, that the Norwegian population has changed the last 50 years, and that means that there are more minority groups than it used to be. And some of the cases that have occurred frequently is about the relationship between freedom of expression and hate speech, which is linked to your question. And we've had several cases where we have convicted people for having gone too far in their negative statements about minorities. I think that's an important development we've had in our case law. It started already in the 1980s, 90s, but it has developed further, and we had a case like that rather recently, I think just the beginning of this year, where we again convicted someone for having come up with prejudicial remarks because of person's origin, and we increased the punishment for that kind of statements.
That's an actually a very interesting area where you can see how the Supreme Court has changed its direction. I think if I remember the case, I can't remember the exact case names, but it involved a march of the Boot Boys in Askim, and that case went to the Supreme Court, and the Supreme Court decided that it was not a violation and it was protected speech. But then I think it was the Committee for the Elimination of Racial Discrimination who said no, it was should have gone the other way. And similar cases after that, then the Supreme Court then reflected the committee's view instead of its previous.
There has, as always, these balancing situations are complicated, both for the international organs and for the national organs. And I think that when it comes to protection for vulnerable groups, we have seen a tendency in favor of protection of minorities in our case law. Whereas if you look at, and that means to some extent a slight limitation in the freedom of expression area. But if you then look at other areas of freedom of expression, namely where it's about discourse of public matters, discussion of important issues which are vital to a real democracy. There, human rights, the freedom of expression principles have been strengthened over the years. So I think you can see how case law has developed in different directions in a way, depending on the underlying interests. And both tendencies have been inspired by human rights law.
So just to round up then, from your last sentence, we can say that the Supreme Court here in Norway very much takes into consideration human rights and is affected by international human rights as well.
Yes, I would say so. You will always find someone who would think that we should do more or should be even more human rights friendly. But the Supreme Court, because there will always be someone who loses a case. But I really think, and I think that's shared by quite a few, that our attitude has for decades been open to the human rights tendencies, and we follow case law closely in Strasbourg in particular.
Thank you very much for your time, and I'm sure that the students in our intensive course will benefit greatly from all of our discussion here today. Thank you.
Pleasure.